Good afternoon, everybody. Daniel Sherman here. As you can see, the camera's a little different. I'm driving a different car. This is my wife's car. So the angle's a little different. She's got a hands-free device. It's supposed to be laying in the cup holder. So I guess it's a little safer. Maybe, I don't know. So I promised you all I'd talk about Rule 901 and 902. Those are authentication of certain documents. And it really, it's for me, it's a misunderstood rule by a lot of attorneys and a lot of courts. They confuse 901 and 902, and here's kind of what I mean by that. So, Rule 902 is the self-authenticating provision. So what that means is certain documents automatically are considered authentic. So typically those are going to be certified records, say from hospitals, certified records from the records custodian, to the cabinet records, certified records of court records where the clerk certifies. And really, to certify something, the clerk basically signs an affidavit, typically affixes a seal. Doesn't have to be, there's some exceptions for that. You do have to, if you're going to do it the certified way, you do have to make it available to the other side, which happens in all cases anyway, because, disclosure in criminal cases, and then in civil cases, you got discovery and pretrial compliance. So that is what self-authentication is. Now there's some other things in there, so like periodicals and newspapers. So if I introduce the New York Times has an article, like just introducing the newspaper itself is self-authenticating. There's nothing else you have to do. I can't say that happens very often in criminal cases, but certainly it can happen in civil cases, especially if you're talking defamation cases, libel cases and things like that, where it's in print, so you gotta introduce that. But and the reason that there's some confusion is because it's easy to self-authenticate something. It's easy to have a certified record. The court knows under that rule, hey, it's automatically certified. You just have to say, Judge, hereby introducing a certified copy of my client's medical records, file it. That's all. That's the authentication part. And there's often a confusion that is the only way to introduce documents, and it's not. So I'm going to come back to that later, because Rule 901 deals with typical authentication. So that's going to be if you have somebody, when I talked about text messages earlier, they have to say, I'm familiar with this, and they fairly and accurately describe, the text messages on that day, or, if it's a recording, fairly and accurately describe the recording. You get it mostly of pictures, like say if you're in a car wreck, and you take pictures of the car. If you were to go to trial, you would testify, hey, whether you took the picture or not, you don't have to take the picture. Hey, that's a fair and accurate description of my car after the wreck. That authenticates the document. And so most documents, if they're not certified, are typically authenticated through, the people that are familiar with them, that have them, that's in their custody. So they know the records are authentic. Like, you took the picture, that's your car. That will allow the court to say, okay, they're authentic. The problem becomes when you have documents that are not certified. When can they become authentic? So they don't have to be certified to be authentic. The best course of practice, of course, is to get them certified so you don't have to have this argument. But there's some things you're just having difficult times to get certified. You just are. And so when you have things that are not certified, you have to show certain things to the court. Number one, you have to show the person that's introducing it is familiar with them. Best example I can give are if you try personal injury cases, medical bills. Medical bills typically aren't certified by the hospital because they're not really kept in the regular course of business of the hospital. They're sent to the patient. So rarely will you get certified medical bills. So the person that has to certify it is, the person that got the bills. And they're going to say, hey, look, I've got these bills. They are true and accurate. This is what the hospital sent me. This is what I owe. I'm familiar with these. And you can do that with a lot of other things and a lot of other documents. If I had this the other day, the judge denied it. I tried to explain to him. He disagreed with it. I think it was an unsubstantiation cabinet record. I was going to introduce the original letter. No, that wasn't good enough. You need to have the records custodian. Why? No, you don't, because you sent it to my guy. It has my guy's name on it. It's my guy's property. He can authenticate it. It doesn't, even though it's prepared by somebody else. Just like the medical bills, they're prepared by somebody else, but they're yours. So just like that substantiation letter. So there is a lot of confusion with documents, specifically documents from, say, public agencies, or any other documents like PVA records. Like, you don't have to have, and I had that as an argument, you don't have to have the PVA person come in and certify it. You can say, I went to the PVA office and I printed this out. And as long as the court can make a sufficient finding that, hey, look, these look like they're authentic. Like, they don't look like they're forged. I've seen PVA records before. This is exactly what they look like. That's authentication. So it doesn't have to be, it doesn't have to be something that's certified. And I try to get that across in a lot of my cases. And, part of it is, sometimes it just, it slips through the cracks where I don't have them certified. Because some of these, especially domestic cases, like if I had to subpoena every single, records custodian, I would just be doing nothing but putting on records custodians to say, aren't these the records? I have 12 witnesses just to do that. So it's really inefficient, and the rule's not really designed to do that. But main thing, if you're going to authenticate something, either number one, it has to be self-authenticating, and I've gone through that, and there are like 10 or 11 other exceptions, things that are automatically self-authenticating, or you have to produce somebody that has actual knowledge of the document. So it could be, like I said, medical bills. Typically those are going to be pictures, text messages. Hey, look, I sent that text message. Hey, this is a picture. And you have to use, especially when you're introducing pictures or photos, that fairly and accurately identifies, describes the object on that day and that time. So fairly and accurately. As long as you say that, it typically will come in. So that's authentication, and lawyers, I guess, make it harder than it needs to be. And I will say this, the hardest thing you will ever do in trial work, and I do a lot of it, is introducing evidence. And some of the times it's hard because there's just certain things you have to do. There's a procedure and you better know it. And the other thing, sometimes the rules can be misunderstood by, opposing counsel. I've had like 2 domestic cases, or maybe 3 domestic cases in the last month or 2, where it's just like, no, you're not getting the rule right. Like, this is what the rule says. I'm explaining to you the rule. And then they want to say, well, it's hearsay. Well, no, it's not hearsay. Here's the exception to hearsay. And you get through all that stuff. So, and just by so public records, not police reports, but public records are exempt from the hearsay requirement. So just to let you know. So if you're trying cases and a judge says, I think it's Rule 807, if it's a public record and they say, well, okay, I'll find that it's authentic, but it contains hearsay. Well, it's an exception to hearsay. It's a public record. So I guess that's my rant on authentication, because it's completely misunderstood. I know you guys probably still don't understand it. Sometimes I don't either, but that's the rule. And so if you're going to introduce evidence, that's what you have to go through, and that's kind of what you have to fight. So hope this has been informative. It's been about 10 minutes. It's about how long I think it would take. So this is lesson number 4. We'll go to lesson number 5 next. I may do hearsay. Like I said, I want to save that for last. if I do some other evidence, I may sprinkle that in before I do hearsay, because hearsay is going to be a lot, and I may have to do like different rules, different record. I may have to do 30 different videos to describe it. So I hope you all have a good rest of your day. If you have any questions, comment down below. You all have my phone number. Take care.